You're listening to Colorado Chamber Office Hours, a podcast that explores what matters most to business. I'm your host, Ed Sealover, Vice President of Strategic Initiatives for the Colorado Chamber of Commerce and editor of the Sum and Substance. Let's get talking. Welcome back to Colorado Chamber Office Hours, the show where we dive into both the high-visibility business bills moving through the Colorado Capitol and those that may have a lower profile but be just as important. And today's episode deals with legislation that falls into the latter category, namely House Bill 1054, which seeks to boost protections for worker safety. Now, it does this by setting up what might be described as a Colorado version of the Federal Occupational Safety and Health Administration, more commonly known as OSHA. The bill sets standards for workplace safety, gives the Colorado Department of Labor and Employment and the Colorado Attorney General's Office the ability to investigate workplace health and safety concerns, that's a mouthful, and allows for aggrieved parties to file civil lawsuits over purported violations. We're going to start this week with an interview with Cole Wist. Now, legislative observers may remember Wist as the former assistant minority leader in the Colorado House about 8 years ago, but Wist cut his teeth as an employment attorney and has some acute insights into what this bill could mean for Colorado employers. Cole, welcome to the show.
Thanks, Ed. Good to be with you.
Let's start with a broad question. How significant could this bill be for Colorado employers?
Very significant, and anytime you're talking about regulating the workplace in any way, the onus should be on the regulator to be clear. And my biggest concern with this legislation is that in the interest or in the spoken interest of improving worker safety and health, we are increasing confusion in the workplace. And anytime you create confusion in a regulatory environment, you increase costs, and ultimately you don't get a better result. So my challenge to the sponsors here is if you're truly looking at improving worker safety and health in the state of Colorado, let's create a clear framework so that both employers and employees know what's expected of them from regulators.
Let's dive into that in a little more detail. How does this bill create confusion? Maybe if you could kind of give an outline what this bill does do and what we're not sure if it does.
So the Federal Occupational Safety and Health Act dates back to the 1970s. And under the Federal Occupational Safety and Health Act, the federal government regulated occupational safety and health in all workplaces, except for those that are regulated by a more specific agency, such as the Mine Safety and Health Administration, the Railroad Administration, or Federal Motor Carrier Safety Association. So essentially, OSHA is the default law that applies to workplaces. Now, also under the Federal Occupational Safety and Health Act, the federal government said that states can regulate occupational safety and health in place of federal OSHA if they go through a process called setting up a state plan. There's a very specific process to set up a state plan. It's a multi-year process. It begins with an enacting statute that creates the agency in the state that's going to enforce safety and health. And then that agency promulgates regulations and enforces the regulations in the same way that federal OSHA does. My biggest concern about this bill is, and this is perhaps a creation or result of the fact that we don't have a lot of spare money lying around the state capitol these days, but they're not creating a state plan. They're doing state plan light, if you will, and as a result of that, injecting a massive amount of confusion that will result in a lot of work for lawyers, but not a better environment for businesses.
So what kind of specific things would this bill allow the state to do that it does not do right now?
So in Colorado right now, we are a federal OSHA jurisdiction. Now, unlike the states around us, Utah, Wyoming, New Mexico, and Arizona, which are state plan states, the U.S. Department of Labor regulates workplaces in the state of Colorado. Colorado has no place in enforcing workplace safety and health standards. They can't cite violations of standards. That's exclusively a federal function. So one of the issues that I've heard the bill sponsors talk about is their concern that the Trump administration will roll back protections that exist under what's called the General Duty Clause, which is a broad provision under the Occupational Safety and Health Act, Section 5A1. And I'm geeking out here for a minute, but bear with me.
Please geek out with us.
The Section 5A1 says that employers are required to provide a workplace for their employees that are free from generally recognized hazards. hazards. And it's sometimes just determined to be the catch-all provision. If there's not a specific OSHA standard that deals with the condition, OSHA will cite a violation of the general duty clause. The proponents of this bill are concerned that the Trump administration has signaled an intent to retreat from the way that the general duty clause has been enforced in federal OSHA jurisdictions. So my understanding of what this bill would do would be to create an alternative general duty clause in the state of Colorado and possibly create regulations that are in companion to or adjacent to federal worker safety standards. And the big problem is under this bill, there's no enforcement mechanism. So the state is not going to have inspectors that will go out to the workplace and look at conditions or issue citations the way federal OSHA can do. So if I'm an employer in the state of Colorado faced with this new set of regulations, this new general duty clause, I'm going to throw up my hands and say, gee, I'm confused. I'm not sure which framework applies to me. And anytime you have confusion, you have increased costs, and I would say not better government for the state of Colorado.
Now, in lieu of compliance, it looks like the bill does set up a new right of action for people to file civil lawsuits. Is that common? Is that kind of what you do when you don't set up compliance standards?
I think it's a horrible way of setting up an enforcement mechanism. In other state plan states, and I've litigated before a lot of them, there are 22 state plan states that regulate workplaces and 7 that just regulate workplaces for public employees. And even in a state plan state like California, there's a system set up for regulatory violations, fines if there are regulatory violations, and then a system for adjudicating when there's a contest about those. My big concern is that if we essentially allow our civil court system to become the place that's going to adjudicate workplace safety violations, we're going to have an administrative law judge through the U.S. Department of Labor that may be adjudicating citations that are issued on the federal side. And over here, we're going to have a civil court system where we're going to have litigation about the same set, arguably, of the same set of infractions. So I think you could have inconsistent results. And again, I keep coming back to the issue of confusion. But when you have 2 judges looking at the same set of facts and different regulations, or perhaps the same regulation, they could reach opposite conclusions. And from a precedential standpoint, that's very problematic.
What does this all mean for employers? If this were to pass, what kind of things would they have to do differently, both to prepare safety in their workplace and to comply with this?
Well, I would still advise my clients to look to the federal government. Until Colorado enacts a state plan, my position as a labor and employment lawyer representing employers in this state is that we're governed by the Federal Occupational Safety and Health Act and the U.S. Department of Labor Occupational Safety and Health Administration. For those in mines, it's the Mine Safety and Health Administration. For pipelines, it's PHMSA. So there are federal agencies that regulate safety and health. This has been pretty clear since the 1970s. I don't understand why we're at this point injecting confusion, other than this seems to be what's happening across our country, and that is where states disagree with the Trump administration, they're trying to push back and enact their own set of regulations and rules. And my only position is I don't have any fault with those who say they'd like the state of Colorado to regulate worker safety and health. That's a completely legitimate policy objective. But there's a process to go through that. It's called a state plan. This is not a state plan.
This may be a bit of a moot question because the way this is being set up differently than plans with state plans, but do we see differing outcomes in states that have their state plans? Are there more violations, more civil lawsuits? Do we see anything differently than in a state like Colorado that's now federally overseen?
So if you ask that of the state of California, I would say absolutely. It's more strict. The regulations, and in order to have an approved state plan, the state has to enact standards or regulations that are as stringent or more stringent than federal OSHA. And I can tell you that Cal OSHA takes that very seriously. They have a lot of very strict regulations. They're a very aggressive state in terms of enforcing the regulations. And that's the beauty of the state plan system, and that is the state can design a system that works well for them. Wyoming certainly has a different approach than Cal OSHA. And in some states where there are state plans, the regulations essentially mirror what you see on the federal side, but the enforcement piece is happening at the state level. Some states like having inspectors who are from their state, who may recognize the particular culture or the work environment that's unique to that state may be better served by having a local agency rather than a federal agency performing that function. So I think this looks different in each state, but I think that's the beauty of this hybrid system that we have in terms of worker safety and health. It's worked pretty well for a long time, and Colorado appears to want to turn it on its head, which I think is a big mistake.
Well, we're going to see here soon enough whether or not legislators agree with this idea. Cole Wist, prominent attorney, former Colorado Assistant House Minority Leader. Thank you for coming on and speaking with us about this.
Great to be with you, Ed.
All right, now we are here with Representative Elizabeth Velasco of Glenwood Springs, one of the two Democrats who is co-sponsoring House Bill 1054. We explained a little bit about what the bill is about. I'd like to start, Representative Velasco, by asking you, where did this come from? What made you decide this is what we need to do for state workers right now?
Yeah, I've been working on protections against extreme temperatures for workers for years. I am an environmentalist. I believe that climate adaptation is a place where we cannot afford to leave anyone behind. So to me, this is all related. At the federal level, we're seeing these federal infrastructures that are being defunded. And this last interim, me and my staff, we went to a conference that was about workplace safety in Chicago, Illinois. And some of the attendants that were there were gathering public comment because the federal OSHA was collecting public comment on the general duty clause because we knew that it was coming, that they're going to roll it back. So at that time, we made a comment so that they could add it, stating how important this rule is for workers. And then we started, we also have another bill about extreme temperatures to protect workers. But as I see it, this is about making sure that workers can go home after their shift and are able to make it to their families after their shift. And we are seeing different labor bills that have an aim at supporting workers, from the making it easier for workers to organize, or this bill that we're running around the general duty clause and protecting workers against extreme temperatures. So we believe that as these rules at the federal level are rolled back, that is important for us to step up as the state.
And obviously, state employers are used to being regulated by OSHA. This is a kind of an interesting hybrid, and maybe I should ask you about that. It's not creating a state OSHA plan necessarily. How would this bill work, and why go about it that way rather than saying, we're just going to go full on in and create our own state OSHA plan?
Yeah, so we are just including the general duty clause into state statute. And this general duty clause, it says that employers have a responsibility of keeping employees safe at work. And we are adding that provision around the AG being able to bring forward claims, and also for labor organizations or workers to bring injunctions so that they're able to stop if they feel unsafe when they're on a job site or at a job order. And this is definitely, like you said, a hybrid, because we are adding those protections at the state level. But as I mentioned in committee, this is already the law at the federal level. So this is nothing new. This is something that employers must comply with and have been mandated to comply. So we're just making sure that if it gets rolled back, that we have it in state statute. And then we are adding this enforcement mechanism, because at this point, during this administration, when people and workers are dying on the job, we believe that we need something now. We need something that protects workers now. And of course, I would love to have an OSHA at the state level like other states do. But as we heard, that would take years. It would take a lot of resources. It would take a whole process. And with our budget environment at this point, when we cut $2 billion from the budget during special session, we have a $800 million that we have to cut to approve this year's budget. So the fiscal notes and starting a new program seems pretty impossible.
And understandable that you're looking at, hey, how do we replace some of the protections that the feds are looking to roll back with this kind of unique enforcement mechanism that you're setting up here? How much will that? Obviously, you don't have kind of the long tentacles of an enforcement agency coming in and doing the same kind of inspections and enforcement that the feds would now. How much would this help this kind of new design that you're looking to create here?
As we see it, we don't believe that we're going to have 1 million claims, that the courts are going to be overwhelmed or nothing like that. Like, we believe that this is a way of holding bad actors accountable. So we're expecting that workers are able to utilize this tool, and that this is kind of like a safety net. Because right now, I was talking to an OSHA trainer. He was telling me that we have one OSHA inspector in the whole state that is certified, and that he in the past had seen that there was an OSHA inspector per 1 million people. So that's already reduced 3 times, from what he had seen in the past. So as we are seeing this OSHA process be defunded, being changed, protections being rolled back, we do believe that this is a way for workers to be the ones that are enforcing the rules.
And it's a good way to put it. It's a safety net system here. Are you worried that there could be any confusion for employers about who is enforcing the rules in terms of what they have to follow on a federal standard versus a state standard?
Yeah, I mean, I think that's an interesting point. And as I mentioned, we're not creating anything that is new. Employers are supposed to be following these rules. So we hope that they continue to provide safe workplaces where people are able to make it home at the end of the day.
You have talked before about the varied backgrounds that you have. You've had a lot of careers. As you look out, what workers do you think are really most in need of these protections that a bill like 1054 would provide?
I definitely think that our what we call essential workers, people that are not able to stay home and work from their computer. These are people who are working in manufacturing, people who are working in construction, in trades, and people who are working with their body, literally putting their body to use and making money that way. So it's I believe that those are the workers that we have to protect. I have seen definitely the different types of risks, from working as a wildland firefighter and working as a public information officer during emergencies and being an interpreter and translator in hospitals. These issues that we're seeing are going across a lot of different trades, different industries. We have even heard from teachers, where the schools are closing because they don't have AC, and it's so hot that kids cannot be there. Workers like teachers are not able to be in the building. So these provisions really are life or death for many of our workers.
And is there a message that you'd like to send to employers with this bill? And I realize that I'm not saying that in a threatening way, but is there something that if this is so important that you want to establish these new state parameters for enforcing what the feds are not going to be enforcing, what should employers take away from this?
I think what employers should take away from this is that, we want workers to be safe at work. We want them. And I also see this as a smart business investment, because if you have less injuries, if you have workers who are not at risk, who are able to make it to work the next day, that's good for business. That's good for your bottom line. That's good for profit. It's good for people to make their money and be able to, make ends meet. So this is definitely not trying to threaten our employers in the state, but it's more about making sure that our most vulnerable are protected, that nobody's dying on the job.
That was Representative Elizabeth Velasco talking about House Bill 1054, which passed out of its first House committee on Thursday night. We'll be discussing this bill more as it moves along this session. Representative Velasco, thank you for talking with us today.
Thank you.
That's it for our interview segment. Now let's take a quick look at what you need to know about the week ahead. Once again, we have 5 bills that you will want to watch this week. On Tuesday morning, upon adjournment of floor work, the House Judiciary Committee is scheduled to finally consider the twice-delayed House Bill 1012, which was the bill we featured in last week's episode. This is the proposal to declare that it is price gouging if vendors at captive consumer facilities such as airports, sports arenas, and large outdoor festivals charge more for their goods than the average price of, say, a hot dog or a beer in the county in which the venues are located. Pitched as a bill to fight what its sponsors call funflation, this measure is opposed by the Colorado Chamber and many other business groups because they believe it adds unrealistic pricing regulations, all backed up by the threat of potential deceptive trade practice lawsuits, to businesses. The hearing is set for House Committee Room 107. That same morning, the House Health and Human Services Committee is set to take up the first 2 bills of the session that deal with artificial intelligence. HB 1139 regulates and limits the use of AI in healthcare, and HB 1195 does the same thing specifically for the field of psychotherapy. These are preludes in many ways to the big debate that is expected to come later this session on the regulation of the greater AI industry. But they each could impact their specific fields quite substantially. As such, business groups like the Colorado Chamber are looking for amendments, specifically on HB 1139. The hearing is scheduled for House Committee Room 112, and the bills are 5th and 6th on the agenda. On Thursday morning, upon Senate adjournment, the Senate Business, Labor, and Technology Committee will hear Senate Bill 93, which would bar local governments from issuing building permits until the general contractor and all subcontractors on a project have proven that they have workers' compensation insurance. While sponsors call this a bill to protect workers from shady contractors, the Colorado Chamber and a whole lot of contractors groups oppose the measure, saying it will further delay the already slow construction permitting process, particularly because many general contractors don't even know who their subs will be until after they receive a building permit. The hearing is scheduled for Senate Committee Room 352. Lastly, the Senate Health and Human Services Committee has a lengthy committee hearing scheduled for 1:30 p.m. Thursday that includes confirmation of nominees for the Colorado Air Quality Control Commission and a hearing on a bill that proposes to establish a new mental health services enterprise funded by a fee on everyone who purchases internet services in Colorado. But the bill that's drawing the most business attention, and the opposition of groups like the Colorado Chamber, is Senate Bill 41, which would give the Attorney General's office the ability to block mergers and acquisitions in the healthcare industry if they lessen competition in the sector or have a negative effect on consumer welfare. Health systems are particularly worried about the potential impact of this bill, which is scheduled to be heard 6th on the agenda in the old Supreme Court chambers. That's all for this episode of Colorado Chamber Office Hours. Once again, I'm Ed Sealover, Vice President of Strategic Initiatives for the Colorado Chamber of Commerce and editor of the Sum and Substance. I'll keep the conversation going at tsscolorado.com, and we'll see you next time as we explore the issues that matter most to business.